Lawyers, has there ever been a time the opposing counsel accidentally proved your case for you and what happened? Not a lawyer, but represented myself against an employer who terminated me. I spent hours upon hours, day after day, preparing for this case. I printed out emails, recorded telephone calls, mountains of evidence. I wore my best suit and, nervous as all frick, showed up ready to plead my case. When I get there, my former employer opens with "We terminated Wilkerson for truancy. He was supposed to report to work after his doctor's appointment, but did not show up until 3 p.m. There's an awkward silence. The judge says, "But in your written statement, you claim he didn't report to work until 12 p.m. In the time card you presented to me, it shows that Wilkerson reported to work at 10:30 a.m. More silence. I won. Actually, yes. I was suing the state for damages in an illegal operation by the state police, here in Brazil called military police, or Polícia Militar, but there were hardly any proof. All the witnesses were too intimidated by the cops to talk. There were no images or audios. I advised the guy that his chances were slim to none. But, since I was working with the public defendant office, I couldn't deny the case just because there were little proof. So I did the complaint anyway, here in Brazil called an action, or ASAO, and we went on. In Brazilian justice, the writing part is way more important than the hearings and the talking part. So, when you defend yourself from a suit, you make a piece in writing, called contestation, contestação, and there you must present all your defensive arguments, and cannot present new ones later, unless you can prove that it couldn't be obtained or be known earlier. So, when the state presented its contestation, it didn't have anything but a single paragraph saying that the cop was not under orders, despite being in uniform and in a police vehicle, when he committed the illicit behavior. Basically, they confessed to the cop brutality, and gave us the case. I'm not a lawyer, but a couple of years ago my family was sued by our neighbors for having a fountain in our front yard because it supposedly made too much noise, causing our neighbors to lose sleep. So my dad, being a nice guy, said, "Okay, I'll try to fix it." We put up walls around the filtration unit and redid the pipes to dampen as much of the water splashing sounds as much as we could. After finishing all of this, my dad even got a noise technician, not sure what they're called, to come around the house with a decibel reader to verify that the noise was virtually gone. The tech walked around a couple of times and told us that the highest reading was 28 dB, so that we were good to go. So a couple of weeks go by, no problem, but then we get served with a lawsuit again, over the same issue. So my dad is starting to get aggravated over this, and this time decides to get our own lawyer to dispute this. Well, court day comes and my dad and his lawyer have all the sound readouts, pictures of the stuff we did, etc. Well, the neighbors brought their evidence as well. Their strongest piece of evidence was a recording from inside their house that supposedly showed how loud the filtration unit was, but you couldn't really hear anything except our neighbor lady going, "Do you hear it? Oh, right there. Oh, it's so loud." So when that evidence didn't bear the fruit that they wanted, they decided to show their next piece when ended their case. The next piece of evidence they tried to submit were pictures of our filtration unit, walls, and the various other things we did to dampen the sound. Well, in order to take those pictures, they would have needed to be on our property inside the walls we built. So our lawyer sees us and begins to ask them how they got those pictures, etc. They admit to the court that they trespassed to take those, and thus begins their downfall. Our lawyer showed the judge the decibel report and all that good stuff, leading to our neighbors admitting that the noise actually never bothered them, but it was the sight of our ugly filtration unit. The case was thrown out, and our lawyer then told us if we wanted to countersue we can. So we did. We got them on trespassing and harassment that they provided the evidence for. As it turns out, they were also upset at the fact that the HOA made everyone move boats and trash cans to the backyard. So our neighbors were upset that we got to keep the filtration unit in the front. Like, really? TLDR. Neighbor said koi fountain made too much noise, took us to court, brought evidence that incriminated him in another crime. Case thrown out. We countersue and win. The fish are happy. For anyone who gives a crap, normal conversation, 60 dB, refrigerator humming, 40 dB, whisper, 20 dB, calm breathing, 10 dB. Opposing counsel introduced a highly relevant and bloody crucial piece of evidence during the cross-examination itself. We were really and we had every right to argue that this was deliberate suppression of relevant documents during discovery, but rather than object to its admissibility, we asked for our lunch break to commence earlier so we could take instructions from our client as to how to proceed, which turned out to be a darn excellent course of action. The document prima facie looked supportive of the defendant's case, but it actually in substance was pretty damning for them. We basically came back from the lunch break to rub the defendant's witness face in it, and the witness was so shaken, he broke, for lack of a better word to describe how he couldn't carry on his balls, and completely admitted to his negligence on the stand. He admitted as well that he copied the expert's opinion, instead of giving his own independent evidence. It was a beautiful trial. I'm a lawyer, but this was from my time as a law clerk. Tattoo artist, around 40, gets charged with rape of an employee. The victim is 17, very fragile and barely able to sit in the same room as the defendant. She stares at the table the entire time and you are barely able to hear her speak. She does not elaborate much on details, but basically he forced himself on her after closing the shop for the day. The defendant's story is that the employee came onto him and that the sex was consensual. The defense calls a witness, another employee at the same shop, to basically tell everyone what a stand-up guy the defendant was. If I were to guess, I think the court were undecided, but maybe leaning on a not guilty verdict up until this point. The defense witness takes the stand, starts telling a story of how the defendant, while doing a tattoo on her, tried to hold her down and kiss her, but had to stop because someone else came into the shop. Game over. Pert got convicted of rape. A week later he declared that he was satisfied with the penalty and chose not to appeal. I'd love to think the defendant asked this employee to be a character witness and she smiled knowing that she was going to bury him for being a creep. Not a lawyer, but this happened with my parents. One day in 1993 my sister and I were on our way home from school and daycare with my dad. We were both in the backseat and like most siblings we were fighting. We pulled off the freeway and my dad turned around in his seat to swat at both of us. Then bump. He had hit the car in front of us. We pull over. It was minor. No damage to either car but the woman driving the other car swore her neck was hurting. The ambulance came out and checked her over, gave her the okay. Then she starts arguing with the medics. She demands a neck brace. They tell her she doesn't need it. They give her a neck brace. She wants a ride to the hospital. They say no. She demands it. They tell her that they deem it medically unnecessary and I distinctly remember one of the cops rolling his eyes when she demanded it. Cut to 7 years later. She has burned through 6 lawyers, several doctors. She is suing my parents for $1 million. My parents' insurance company had offered a $500 case settlement and they declined. They are certain they can win at trial. It's the end of the first day of trial. The woman is on the stand. It's about 3 p.m. She's talked about the pain and suffering her and her husband have endured because of it. My parents' lawyer walks up to the stand with a photo. He asks her to describe the vehicle that hit her. She testifies she absolutely clear as a bell remembers looking in her rearview mirror at a white pickup truck coming at her and plowing into her at 60 miles per hour. He turns the photo around. Do you recognize this car? She answers, no, I've never seen that car before in my life. Her lawyer panics and asks for a recess for the evening. My dad has never owned a truck. We had a dark blue 1992 Ford Tempo. The jury sent the guard to ask my parents' lawyer if we wanted any money. We asked for the lawyer's fees only. The jury found in our favor and awarded $200,000 which covered 7 years of lawyer fees for defending against an ambulance chaser. Reddit. She was in another car accident the following month. A guy I used to work with was going through a messy divorce, about 20 years ago now. His soon-to-be ex-wife was a psycho and her father was a psychologist, so he was pulling all of the strings. Even had my co-worker arrested at work one day. BS charges. The divorce case took years, one young son involved, and at every turn, my friend lost because of something the father filed or another string he pulled. In the end, they were in court and it was very apparent that my friend was going to lose custody and all visitation rights. Every plea he entered was squashed and he was mentally broken. The judge asked the ex-wife if she had anything else to add and she said she had a written statement that she wanted the judge to read. The bailiff took the paper from her and handed it to the judge, who unfolded the note and read it. He stopped for a minute and asked her if she was certain she wanted this note added to the case and she said yes. The judge turned to my friend and said, paraphrasing, Mr. XXXXXXX, all these years and all these claims that I ruled against you, the court profusely apologizes. I did not believe you but now I do. Ruling in your favor. Bangs the gavel. I grant you full legal and physical custody of your minor child. Bailiff please handcuff Miss XXXXXXX. My buddy was stunned that he won and happy at the same time. He later found out that the note said give me my son or I'll freaking kill you. Actual lawyer here, and this one was especially sweet, was involved in an ownership control dispute of a Venezuelan company. While we had no doubt who controlled the company, opposing counsel had created enough smoke to create just enough doubt for our federal judge to order us to file a declaratory action. After a few months, we received the equivalent of a declaratory order from the high courts in Venezuela basically saying our client was in control of the company. We had the order translated and certified and drafted a motion explaining to the court how these orders from Venezuela work and how they are in effect the highest law of the land, which meant the case should be over and our client was in control. Opposing counsel drafted an almost identical motion, but they had not received a copy of the newest order. In other words, opposing counsel agreed with our position that these orders from Venezuela would definitively prove who controlled the company but attached the older order. We prevailed in the declaratory action and the judge referenced the fact both sides had the same argument in the final order. Actual lawyer status confirmed. Only people involved with the legal industry, myself included, would find that story especially sweet. My father is a physician and occasionally serves as an expert witness in some cases involving insurance payouts for car wrecks. He had just spent some time explaining all of the different forces involved in the accident and how that could translate to years of back problems. His specialty. He was quite technical in his explanation and the opposing attorney thought that my dad was overreaching his expertise and was talking more as an engineer rather than a doctor. So he asked him if he was an engineer. My dad responded that yes, he was in fact an engineer, as he had a bachelor's in engineering from before he went to med school. It apparently didn't completely resolve the case, but the attorney did have to backtrack quite a bit and it really strengthened the patient's case that the insurance company should continue paying for treatment. Your dad is basically a rocket surgeon now, but work with lots. We deal with car accidents, and this particular girl was claiming severe whiplash and lower back injuries from a minor rear-end accident. Some of her injuries were legitimate, but she was claiming that her life was ruined and she was unable to function in society. She worked as a physical therapy aide studying to become a PT, so she knew just what to say, but she didn't know what not to post on Facebook. She claimed she was in constant pain after the accident and couldn't go to the gym. The day after the accident, there's a pic of her lifting weights #accident can't hold me back. She claimed a month of lost wages, but there she is in a patient graduation from treatment. Photo on her work's website the week after TGE accident. She missed 0 days of work. She claimed that she couldn't travel anymore and guess who had photos of Vegas strippers all over her Instagram for her sister's 21st birthday? She asked for $200K, and she got $9K for the legitimate injuries and mediation, as the mediator laughed at her Facebook feed. Not a lawyer, but a relative of a retired prosecutor. Relative was working misdemeanor criminal court. Cases get called in alphabetical order, and two women named Catherine Smith and Catherine Smith were scheduled to have their hearings before the judge. Not their actual names, but you get the point. Both had similar crimes, but slightly different. So the bailiff announces the next case to the courtroom, Catherine Smith, for 1 count of possession of C with the intention to sell, and 1 count of prostitution. So Catherine Smith stands up and indignantly cries, "Whoa, whoa, just wait a second. Where the heck did the prostitution charge come from? I may deal crack, but I am not a W. Easiest drug dealing case my relative ever prosecuted. Jesus Christ, that sounds like it'd be a scene out of a comedy movie." A while back I was prosecuting an illegal discharge of hazardous substances at a recycling facility. Specifically, the charge was for illegal storage and disposal of CRT glass, which contains lead, cadmium, and a few other hazardous substances. To demonstrate that the owner had no idea that he was receiving CRT glass, the defense attorney introduced shipping manifests that lacked the term CRT, monitors, or any other word that indicated that material. A close inspection of the manifests, however, indicated that the defense attorney had just Ctrl+F the documents for certain keywords, because what the manifests also demonstrated was that this facility, as well as 2 additional facilities owned by the defendant, had been accepting asbestos, hexavalent chromium, and various other hazardous substances that the facility was not authorized to take. That attorney literally handed us the case on a silver platter. I represented a client who was defrauded into purchasing a bad business. The defendant was not willing to settle and all settlement talks eventually halted. Also, the defendant's attorney was pretty slimy and told me they didn't have a lot of the records I was requesting because her computer crashed and had to be formatted. The defendant got a new attorney a year into the case and her new attorney told me about all of these records his client had, several of which proved my case and were supposedly destroyed in the computer crash. His client was clearly not happy. A settlement was reached shortly after. Lawyer here. Had a trial where the basic elements of the claim against my client amounted to 1. That he abused opposing party, and 2. That she was in threat of future abuse. All nonsense, but that's what they needed to show. We get to trial and opposing party, who was supposed to be unrepresented, shows up with 5 lawyers, 2 advocates, and 2 interpreters. But this is a family law issue and these lawyers are from a business law firm. I'm curious where this will go. They put on a case that never once mentions any abuse or threat of future abuse and end by proving that she had secretly moved to another town prior to filing the motion, meaning that he couldn't pose a threat to her because he didn't know where she was. I just pointed out to the judge that there was no need for me to put on a case. WTF. School lawyer here. Had a student claim she aggravated an injury at school because the teacher hadn't followed the doctor's orders. When the doctor got on the stand, he testified that a few weeks after filling out the school form, which we had, he'd spoken to the mom on the phone and ordered some changes to the student's routine. Then mom testified that she'd emailed this new info to the teacher, except we had all the emails, and none of them said anything about the doctor. Mom backtracked and said she must have forgotten because she'd been busy at work. And then, at closing argument, the family's attorney explained to the jury that schools are subject to a heightened standard, willful and wanton, not negligence, and so it was their job to determine whether the school had disregarded a known danger. Naturally, we argued that the school couldn't well disregard a known danger if no one had ever told them about the new routine in the first place. The jury agreed. Not a lawyer. My wife got hit by a drunk driving teenager years ago. Parents have $$, $$, and friends with the cops, so they get it hidden that their daughter was super drunk. She couldn't even stand up, according to some nurses who lived across the street and responded right away. Their insurance refuses to pay without evidence. Wife tells lawyer to take it to court. In deposition, the teenager freely admits she was drinking. Says it totally changed her life. She couldn't believe she almost killed someone. She's never touched a drop since and really sorry for all of this that her parents have done. Insurance company lawyer looks at wife's lawyer and says we will give you a call tomorrow. Whoa, can't believe that apple rolled that far away from the tree. That said, one could argue parents protecting their child is a good thing. But at this point it was only about money. So yeah, frick them. My wife is a court clerk. She told me a story a court clerk friend of hers told her. D has a shaky case at best against a defendant. Police were trying to pin a drug charge on a guy with literally zero evidence. The report read that a certain amount of weed and M were found and recovered in the defendant's car, but the evidence was lost. Guy maintains his innocence and has no priors. The defense attorney is destroying the officers on the stand for inconsistencies between their accounts and poor documentation on the official police report. The prosecution's ace in the hole was a part of the police report that read something to the effect that the police K9 said there was marijuana and M&D in the car, rather than saying something like the police K9 alerted the officers to the presence of drugs. It left the defense attorney no choice but to call the police K9 to the stand to confirm its testimony. That drops the case. Yes, I used to videotape depositions many years ago. Client was suing insurance company for 2 years back wages after an injury. Conversation went like this. Insurance lawyer. It says you're asking for $120,000 for 2 years back pay. Client. Yup. $60K per year. Well, we have your previous tax returns. Those are only $30K per year. Client's lawyer. I'd advise you to. Client. I know. I only put that on my tax form. I actually make much more. The insurance lawyer very calmly asked to go off the record. He said, well, your client just admitted to tax fraud on video. This case is pretty much done now, and I don't want to put you out, but I need to figure out whether or not I'm legally compelled to tell the judge or IRS about this. We'll be in touch. TLDR. Guy suing for back wages admitted to tax fraud on video deposition. Former lawyer here. This happens with pretty good frequency, but not at trial and in a different manner than you are thinking about. In my direct experience, the most common way the state got one of my clients off the hook was via forensic subpoenaed evidence that takes some time to come back. However, this happens well before the trial. It goes like this. There is a violent crime and evidence is gathered. 2 eyewitnesses swear they saw my client at the scene. Cops arrest my client based on eyewitness accounts. I meet with client for the first time. He swears he's innocent and was at his girlfriend's house at the time. A few days later cell records come back and forensics come back and proves that my client was elsewhere and I get him immediately released. Because I'm sure to be asked, I practiced in NYC in the pre-video cameras everywhere era. Eyewitness accounts were the first and fastest avenue for cops to hit a suspect. It was very common for rival criminal outfits to falsely snitch on each other to get the competition off the streets for a few days, or just to frick with someone they didn't like. From the cops' perspective, they get put in a bad way. If there's, say, a murder and you have 2-3 guys who 1. Swear up and down they were right there and 2. Swear up and down that they saw the suspect commit a crime. The cops aren't really in a position to not arrest the suspect pending further investigation. Did work experience at a trial where the victim flat out stated that the defendant was innocent. Turns out she's pretty bad at English, so when she gave her account it appeared that the defendant had committed a crime. They then gave her a witness statement to sign. She can't read no good so just signed it anyway. This all came out at testimony whilst the prosecution lawyer desperately tried to get her to rephrase what she said. Funnily enough, the trial wasn't immediately thrown out, so they brought more witnesses in to testify, all backing up the wrong account of what happened. This all came out at testimony whilst the prosecution lawyer desperately tried to get her to rephrase what she said. Funnily enough, horrifyingly enough, the trial wasn't immediately thrown out, so they brought more witnesses in to testify, all backing up the wrong account of what happened. FTFY. A barrister friend told me about a case observation she witnessed during her training. A guy was up for sex with a minor and he adamantly insisted to his lawyer that his defense was that he had never even seen the girl, yet alone met her. This despite witnesses in the bar and incriminating CCTV footage showing someone who looked like him leaving the bar and going to his car in the car park. When he was questioned, he steadfastly stuck to his story. When the questioning ended, there was a pause and he yelled at the judge, "There was no way I could have known she wasn't 16 when she sucked me off," literally blowing his whole case. Accidentally proved? Not often. Made tactical errors? Often. Arguing a case on a voter recount in front of a judge. Judge says, "I'm going with X. That's in my favor." So I shut up. Opposing counsel, in arguing a different point later, suddenly goes back to the earlier point and belabors it. Client, also a lawyer, says to me, "Don't say anything." I whisper back, "Don't worry, wasn't planning to." Judge begins rubbing his nose and looking irritated. After a few minutes, cuts off opposing counsel, saying, "I already ruled on this point, Mr. Smith." Me. Anything to add? I replied in the negative and won my motion. Would it have come out differently? I don't know. Did opposing counsel make it easier for me? Absolutely. IAAL. This was a restraining order case. My dude had allegedly been within 500 feet of his ex. At trial it came out that she had told my guy that she had told him the restraining order was dropped. Hence he couldn't have violated the restraining order willfully. Judge got furious and dismissed the case. It's amazing how many people miss that part of a restraining order, usually reinforced by the judge. It goes both ways, and if you intentionally violate the order, you can be in trouble, too. Not a lawyer, I know, but my parents were in a lawsuit where this happened. They owned a business, and on the either side of it were businesses as well. Their neighbor to the left sued us, claiming that we had been using their property without paying them or without permission. That we were essentially trying to adverse possess it. We got a surveyor to come in and the surveyor said that not only were we using all of our property, but we had been paying rent to them on about 20 feet that was also our property. Obviously they weren't happy, so they got their own surveyor, who gave us 50 feet. We won the lawsuit. Now their little patch of property has a rusty fence all around it with keep out signs everywhere. It's about 20 x 10 feet. I am not a lawyer, but witnessed a pathologist win a case in court by destroying the defense's credibility. The question was over whether or not carbon monoxide poisoning could have caused certain signs of death in an individual. But the defense didn't study their chemistry very well and kept asking the pathologist whether carbon dioxide could have caused these signs. After thoroughly frustrating the defense by answering his questions incorrectly, the pathologist said very loudly, "Oh, I'm sorry, did you mean carbon monoxide? Because that's a completely different thing." Completely destroyed the defense's credibility in front of the jury. They were done after that, so I guess the opposing counsel screwed himself by not picking up a book. Not very interesting probably. I work in land law. Had a guy file against us one time for adverse possession of about 20 acres of pretty valuable land. Adverse possession is a legal method to acquire legal title to property of another after some duration of time passes and other factors are met. Open, obvious and hostile possession, etc. Long story short, the guy sued his neighbor, our client, due to a fence being placed in the wrong spot. Both sides assumed it was their property line. Turns out after being surveyed it was not, and actually those 20 of our acres were on the plaintiff's side of the fence and that fence had been there for a long time. Anyways, in their pleadings and evidence they tried to put on their strongest, most persuasive evidence by saying the plaintiff had been on the property forever and had always used it, worked it, etc. That sounds all good and great, except their lawyer didn't know the law well enough. Which brings me to the one other important fact. The plaintiff was our grantor and neighbor. Basically he sold our guy the land, then sued us years later to try and take it back. How fricked is that? Truth be told, the law permits a grantor to adversely possess land previously conveyed, but there's a little sneaky exception to that if the grantor continued to stay on the land before and after the conveyance. The adverse possession clock never starts ticking unless he takes another act, a thing he didn't do. So in all their huffing and puffing, swearing they'd been on the land from time immemorial, they really just killed their own case. It didn't take discovery, a deposition, nothing. They just unintentionally presented their own legally fatal evidence in an attempt to bolster their client's claim to the land. Thereafter all it took was one fairly long letter explaining this and the case was dismissed after a nominal payment from us. Basically buying off their appeal to not waste our time as no ATI fees were in the mix. As I stated above, this probably isn't very interesting to anyone, but it sure gave us a good laugh and a story to tell. I am a lawyer who defends a state from injury claims. There was a claim where there was a dispute as to the value of a state employee's injury. We went to trial to argue the extent of the injury. When the employee takes the stand and is under direct examination by her attorney, she is unable to answer basic questions about her name and address. Everyone just thought it was nerves, but eventually the employee confesses that she is a convicted felon and she stole her sister's identity to obtain the state job. Judge's jaw hits the floor and the employee's attorney just keeps going through his examination like nothing happened. The judge stopped him and had the court reporter read back the testimony. The employee's attorney was still oblivious to what happened. The judge recommended the employee drop her case and quit her job immediately. The employee's attorney wanted to keep going. The judge then told him that his client will drop her case and quit. Case was dropped and she quit that afternoon. The vast majority of the time, it's not an opponent who directly proves up my case but the expert. She hires instead. It's only happened twice in my relatively short career, but these types of cases usually settle real quick after the shortest depositions of my life. L. Do you have an opinion on what may have caused plaintiff's spinal condition? D. Yes. L. In your opinion, within a reasonable degree of medical and surgical certainty, could it have been what happened to him at work? D. No. A lot of doctors charge for a pre-interview before a deposition and a lot of attorneys hate paying, so I understand how this can happen, but I've got to feel for the guy at the end of one of those deps. Best I ever saw was a psycho neighbor. Their name is Fig Jam, which stands for frick I'm good. Just ask me. We had that used to move to a new place. Pick fights with neighbors on all sides. Move, rinse and repeat. Massive piece of crap in general. Well, one day their neighbor, Jim, over their back fence got a bizarre legal document stating their intent to sue over a tree in their yard whose roots had supposedly moved 20 meters down the hill to restrict and break their pool pump and the piping for said pump. So, Jim in his defense pulls in a plumber, who happened to be a mate, to dig up the trench and extract said roots for DNA testing in a lab. When they did this, they spared no expense. We're talking 15 people on site. We're talking bobcats. The fricking works to make it the most expensive trench they could. Funnily enough, the DNA tests proved it was from Fig Jam's own tree, which was a lot closer to their pool pump. Who'd have thought it? They were liable for cost of their Jim's legal defense. The plumber and the lab hit Fig Jam with a $30,000 bill. Couldn't have happened to a nicer person. Till people do forensic DNA tests on trees. If you are new to the channel, you can subscribe. I publish new videos every day. Until then, check another video. Bye for now.